Hi there, David. How are you?
James, I'm fine. All well with you? Reading all these cases and statutes that are churning out, are you?
Absolutely. And on that note, we're here to talk about our suggestions for a top 5 of pensions cases from the last year.
Yes, although we need to define our terms a bit. As good pensions lawyers, we look at the scope of the talk and the proper purpose, and then heavily into the Braganza reasonableness factor.
Okay, enough of Braganza. Definitely enough of Braganza. You can go first. What's your first pick?
My first pick is Palestine Solidarity. So a decision from earlier this year in the Supreme Court. Interesting as a case that went all the way up there, basically on the sort of purpose of a statutory provision in relation to the local government pension scheme, power of the Secretary of State to give guidance, binding guidance, not really guidance at all. It goes all the way up to the Supreme Court, where they decide 3-2 that actually this guidance was not within the purpose of the legislation. The purpose of the legislation was only to do things for pensions purposes, not for governmental purposes in some ways. So an interesting case on 3 points. One, what does it do for the local government pension scheme? Although the government's probably going to try and get amending legislation in. Secondly, what about this reliance on non-financial factors? Bit of a hot topic at the moment. There's some mention by Lord Conworth of how that would apply. It's all obiter, but it was slightly differently worded than what the Law Commissioner put in its report. And thirdly, the importance of just the difficulty of showing what a proper purpose is. 5 judges going one way, 4 judges going the other, and actually it was the majority that went the other way, so they lost at the end.
And it's interesting you say proper purposes, because my first pick is the discretionary increases challenge in BA.
But wasn't BA was 2-3 years ago now, wasn't it?
Well, it feels like that. And the settlement was, I think, agreed in terms in early 2019, but the settlement itself was not approved until November of last year. And it's that the decision in November 2019, which I think is really interesting for 2 reasons.
That's about BA number 5 or something.
Probably, yeah, something like that. The first reason why it's really interesting is that the court actually had argument on what the precise test was for approving a settlement in circumstances where there's been Beddoes relief approving the pursuit of litigation in the first place. And it was argued that in those circumstances, it wasn't just a plain vanilla rationality test. The court had to be satisfied that the settlement was in the best interests of the scheme. The court rejected that argument, and so it stands for that relevant point of principle, and that is of some significance when you're thinking about preparing for having to get approval for a settlement in a pensions case. Second reason why it seems to me it's of interest is to do with the substance of the challenge to the settlement, where it was argued that because of developments after the terms of settlement were agreed, settlement was not reasonable. In particular, reliance was placed by the Rep Ben on the fact that there'd been an announcement that RPI was going to converge with CPIH over time, and it was said that that meant that the benefits of the settlement were skewed to a particular group of members, in particular the older members, for obvious reasons. Now, the court rejected that argument, and therefore serves, as, in a way it expressed itself, as quite a helpful reminder that it's not incumbent on trustees to treat members impartially. In fact, it's of the nature of a dispositive power that it can be used to favour some members over others in practical terms.
It's quite interesting as an example of the use of these sort of buzzword phrases in fiduciary cases, best interests of members of the scheme. I quite like of the scheme approach, and acting impartially. You see these things pushed out there, and actually they're quite difficult to follow or to construe or to deal with. So I'm a helpful case, I think. That brings me on to my pick, which is Let Markey and Cooper, another support.
What? Sorry? I
think he's Finnish. Let Markey and Cooper.
That's a charities case, isn't it, David?
Yes, but lots of fiduciary stuff in there, so which is important for pension schemes. 2 main issues. It was all to do with a split of a charity as part of a divorce settlement between the 2 main movers, billions involved, so it's a huge charity, splitting into 2 charities. Application to court for approval that this was a proper thing to do. it ended up looking at the position of one of the shareholders, of the third shareholder, and whether he had to vote in favour of this proposal to split the charity into two separate charities. And the Supreme Court said two things. One, that the shareholder held his share or rights as under a company limited by guarantee as a fiduciary. So that's a big shift, a move by the courts to say that sometimes shareholders can hold their shares as fiduciaries, might have implications for pensions. And secondly, that as a fiduciary, he had to follow the decision of the court that this was an appropriate thing to do. It was appropriate for the court to give directions effectively to the shareholder, the fiduciary, as to how he should exercise his vote on the shareholder meeting to approve the split. Again, a significant move in fiduciary law. So it's sort of watch this space in some.
I can see that there's an argument to say that has potential application in the pensions context. I see that. My next choice is a squarely central pensions case. It's the big rectification decision of June of this year in Univar. Big trial. Rectification cases don't often get that far, and it had cause to deal with a lot of the issues that you have to deal with in the context of pensions rectification, and therefore serves as a really useful touchstone if you have to remind yourself of how particular issues are dealt with. It had to deal with, one, how you deal with a position where in substance all you can really say is, I didn't intend to do that. You can't say that there was some obvious thing that you were trying to do through the particular exercise in question, just that you weren't trying to do that. There's the subjective objective distinction, again, has to be dealt with in that case. There's the proper approach where you're having to negotiate collective intention. How do you deal with that where there are multiple people involved and you've got to attribute to that collective group a collective intention? And also the old chestnut of consequences versus effects had to be thought about. So a really useful case to have in mind, and it's bound to be for years to come, it seems to me. On top of that, it also deals with a range of issues associated with standalone arguments on opt-out exercises. So it dealt with arguments on extrinsic estoppel, implied exercise of powers, extrinsic contract, implied exercise of powers, and estoppels of various kinds. Dealt with all of that. And obviously those arguments are fact sensitive in the way they're to be dealt with, but it dealt with them, it seemed to me, in a way which is of general application, because it serves as a bit of a warning in rejecting those arguments against attempts to imbue those kinds of documents produced as part of opt-out exercises as having contractual effect.
I think a fascinating case. I mean, hugely expensive, but dealing with this point that there was an unintentional change, and actually there's no evidence that they didn't intend that change. So it's sort of inference that actually had that change been intended, there would be evidence. There'd be some sort of note. There'd be a discussion with the actuaries about the financial costs or something like that. Slightly difficult facts because at the time the change in the law wasn't envisaged or was to do with RPI and CPI changes, which hadn't then occurred. But a hugely interesting case. So clearly the one we're going to have to look back at if there's any rectification case out there.
Indeed.
And that leads me on somehow to my last case, the fifth one, which is also not a pensions case, but which is, I think, quite important. The Grandview Private Trust Company and Wong. If you're looking as though you've not heard of it, it's a Court of Appeal of Bermuda decision. I tried to find a Singapore case, but failed. And that's one to do with a huge private trust, again, billions involved. This is where the money is, clearly. Where the trustees had a power to nominate or change beneficiaries. So it got a wide power, like a wide amendment power. And they proposed to change the beneficiaries, and some of the beneficiaries being excluded complained, and won at first instance on the basis that this was a change that changed the substratum of the trust. That was the key word they did. The Bermuda Court of Appeal said, well, there is no test of substratum. If there is, it's just really a proper purpose test. So the one
that's going to go to the Privy Council, I'm sure, isn't it? And will be a great one to look out for. Well, obviously there are a lot of interesting cases over the last year or so that we haven't touched on there, but I do think that Palestine Solidarity, BA, Letimaki, Univar, and Grandview is a pretty good list.
Yeah, good. Thank you.
Good to chat, David. See you soon.
See you soon.